Chapter 7, Tort Law, Part 1, presented by Kelly Herzick. I broke Chapter 7 into two parts. In Parts 1 and 2, we are going to cover the classification of torts, intentional torts, negligence, plaintiff's doctrines for recovery, defenses to negligence, strict liability, and damages. Let's begin with the classification of torts. What is a tort? A tort is a violation of another's rights or a civil wrongdoing that does not arise from a statute or a contractual right. Torts, like the criminal law, have wider societal aims. A primary objective of tort law is to provide recourse and compensation for injured parties. It helps prevent private retaliation by individuals for injuries suffered. Tort law also helps maintain order in our society and prevent vigilantism. And tort law helps citizens believe that they live in a just society, and it also helps deter the commission of torts, as offenders know they will have to compensate individuals they wrong. To prove the existence of a tort, a plaintiff has to prove all the elements of a tort, while the tortfeasor defendant will generally have the burden to prove any defense. Remember, these are civil cases, and so the burden is preponderance of the evidence. Torts are generally classified as intentional torts, negligent torts, and strict liability torts. For the remainder of Part 1, we're going to be covering intentional torts. Intentional torts are willful civil wrongs resulting from intentional conduct committed against the person, property, or economic interest of another. That's the definition of an intentional tort. Intentional torts occur when a tortfeasor takes an action either intending that certain results will occur or knowing certain consequences are likely to occur. Depending on the tort, therefore, the intent can either be specific, intending to cause the injury, or general, knowledge with a substantial certainty that the injury will occur. While we'll cover insurance at the very end of the course, it is good to know that intentional torts are generally not a risk that is insurable, unlike negligence. Intentional torts against persons are a large category of intentional torts and occur when an intentional act harms an individual's physical or mental integrity. We'll begin our discussion of intentional torts against persons with assault and battery. There are many intentional torts against a person, but assault and battery are two common ones. Assault and battery are actually two separate intentional torts. We're going to start with assault first. Assault occurs when there is an affirmative act by the defendant that places the plaintiff in reasonable fear or apprehension of an immediate offensive bodily contact. And 3, the defendant's act of interference was intentional. Plaintiff's fear or apprehension must be reasonable under the circumstances. Let's take a look at a couple of examples to see what that means. For example, suppose you have a flat tire in your car and you have to pull over to the side of the road. A man in a truck pulls up behind you, sees your car is broken down, and gets out of his car carrying a tire iron. Without more, would that be a reasonable apprehension or fear of a bodily contact? The answer is probably no. It would also be reasonable to believe that the man was simply getting out of the car with the tire iron with the intent to come over and help you change the tire. On the other hand, suppose you're in a parking lot and you take a man's parking space and he gets out of his truck and comes over with his tire iron, waving it in the air and yelling at you for taking his parking space. Would that be a reasonable apprehension of bodily contact in the circumstances? The answer there is yes. He's waving that tire iron around and yelling at you. You could fear reasonably that you were going to get immediately hit with a tire iron. Assault is often, but not always, followed by battery. They usually occur in tandem. First the assault, then the battery. Sometimes it's kind of one long action. So what is battery? Battery occurs when there is an affirmative act by the defendant, an intent by the defendant to cause harmful, unwanted, or offensive bodily contact, and 3, harmful, unwanted, or offensive contact to the plaintiff actually occurs. So what's the difference between assault and battery? Well, assault is simply the fear of being hit or the fear of a bodily contact. Battery is the actual bodily contact occurring. If you have a dispute with someone and the other person raises their fist threateningly and shakes it in your face, you may have the reasonable fear that you're going to be hit with that fist very shortly. That's assault. But if that same person pulls back their arm and punches you in the mouth, that's battery. They've made actual physical contact with your person. Now, battery doesn't have to be just a physical injury. Almost any unwanted intentional contact with another person is a battery. Even if intended as a joke, if a touch would be considered offensive by a reasonable person, the contact is deemed offensive. Almost any type of sexual touching would be considered by a reasonable person to be offensive. So, for example, grabbing someone and kissing them against their will is almost certainly a battery, as is touching them inappropriately. So, how are the torts of assault and battery different than the criminal offenses of the same name? Because you can basically be arrested for assault and battery, but you could also get sued for intentional tort of assault and battery. The elements of the two are much the same, but criminal offenses have to be proven beyond a reasonable doubt, rather than the civil standard of preponderance of the evidence for the intentional torts, assault and battery. In addition, criminal conduct has to violate a specific criminal state statute. Some states have actually modernized their criminal codes and merged assault and battery into assault 1, assault 2, assault 3, assault misdemeanor. Kansas still actually has assault and battery on the books. There are defenses to battery, and they're much the same as in the criminal context. Let's first talk about consent. If a person is being sued for the intentional tort of battery, they can allege that the plaintiff, the person alleging the improper contact, consented to the contact. It mitigates the element of an unwanted touch. There can be no battery if the physical contact made, the third element, is wanted and consented to by the plaintiff. Another defense is self-defense. This involves responding to the force of another with comparable force to defend yourself. Now, it's important to note that the force used to defend yourself cannot be disproportional to the force used against you. For example, suppose someone just punches you in a bar fight with their fist. You cannot pick up a beer mug from the bar that's glass and smash it into their face, cutting their face and injuring them. I actually, when I was in the Air Force, defended someone who was convicted of battery because they used that disproportional force in defending themselves from being hit in the first place. It would be the same in the intentional tort context. There is also the defense of others. This defense allows you to use the same level of force to defend another person as you would to defend yourself. That is basically stepping in front of another person who's about to get hit and stopping the plaintiff from hitting them. That's the defense of others. Then there's defense of property. This one is somewhat controversial and really varies state by state. This defense allows you to use reasonable force to defend your property from an intruder, but deadly force to defend only property is rarely justified. One of the most notable examples is Texas. One of my first law license is in Texas. And when I was taking criminal law in law school, my law professor used to make this joke about if you shoot someone on the stoop of your house, make sure you stick a clock radio in their hand before you call the police. Because in Texas, you can use deadly force to defend property in a lot of situations. I'd like to talk about another tort against the person, which is false imprisonment. False imprisonment isn't specifically mentioned in your textbook, but I think it's an important tort to at least know about as business people because you might actually see it, particularly if you're going to be working in retail. False imprisonment occurs when a person intentionally restricts another person's movement within any area without legal authority, justification, or consent. Here are the elements of false imprisonment: that there was an intentional or willful detention, the detention was without consent, and the detention was unlawful. Actual physical restraint, like holding someone's arm and preventing them from leaving, is not necessary for false imprisonment to occur. Threatening a person with physical harm if they try to leave, if reasonable under the circumstances, can satisfy the element of detention. For example, suppose you're a small person and you're threatened by a big burly guard who's standing 6 foot tall and outweighs you by 100 pounds, who threatens to hurt you if you leave the room. That may be sufficient under the circumstances to satisfy the detention element, even if the guard doesn't grab your arm, and even if there might be an exit behind you, if you're very afraid that the guard will hurt you if you try to leave. A good example, and one that I wanted to raise for you that you may actually see one day, is detaining an employee for an interview on lost inventory for an unreasonable amount of time and not letting them leave the room or call a lawyer can be false imprisonment. It's all about the reasonableness of the detention. For example, if you briefly talk to an employee in a room and don't let them leave about lost inventory, but then when they say, I need to call my lawyer or I need to leave now, and you let them leave, then false imprisonment is not likely to have occurred because the time that they were detained was not unreasonable and you let them leave when they asked. There's also something called the shopkeeper's privilege. Basically, in a shoplifting situation or a theft situation, a shopkeeper can detain a suspected shoplifter for a reasonable amount of time to investigate this theft or to call law enforcement. The next intentional tort against persons we're going to cover is defamation. Defamation is in your textbook, and we're now back in your textbook. Defamation has 4 general elements: a false statement represented as a fact, publication or communication of that statement to third persons, intent or fault that amounts to at least negligence in some states, damages or harm to the reputation of an individual, business, group, government, or nation. It's important to know that anybody who republishes a defamatory statement, even if they cite the original source, is liable for defamation. That means you have to be careful when you're on the internet and on Twitter, any of the social media platforms where you just wholeheartedly cut and paste a defamatory statement, because you could also be liable for defamation by republishing it. If defamation is published in permanent form, such as a newspaper or magazine, this is known as libel. Publication on television or radio is also considered liable because they are permanently recorded. The internet can also be considered a permanent form. Twitter and all the other social media platforms, because they also record, can also be considered a permanent form. Now, damages from libel are generally presumed because damages like humiliation are hard to quantify. Now, on the other hand, if defamation is made orally, it's called slander. People get slander and libel confused all the time. Libel is the written form of defamation, and slander is the oral form of defamation. They are both defamation, but they're just 2 different types. Now, in slander cases, the plaintiff has to prove special damages for slander, meaning that they have to show specific monetary loss that flows from the slanderous statements. It's harder in oral cases to prove damages just because it doesn't stay out there. Stuff on the internet exists forever, and so humiliation can often be presumed because it's very hard to take down something on the internet and get rid of it, whereas an oral statement to a third party presumably isn't existing as long. While in most slander cases the plaintiff has to prove special damages, there is an exception to the requirement for special damages, and that is in the case of slander per se. The courts have created this exception based mostly on the type of statement. Its slander per se is considered inherently harmful, such that general damages like libel are presumed. These are the statements that someone has a loathsome communicable disease, has committed a crime for which imprisonment is possible, is professionally incompetent, or if the individual is a woman, has engaged in sexual misconduct. Statements of opinion, subjective opinions, cannot be proven and are generally not actionable. It's all about how you phrase something, right? If you're just giving your opinion on someone's competence, then perhaps it's just an opinion and it's not an intentional tort of slander. Now, a person accused of defamation, either libel or slander, has two general defenses. The first is truth, and the second is privilege. Truth is an absolute defense, meaning one cannot be liable for defamation damages if the statement you make is true. It may be hurtful to hear, but it's still a true statement. However, just because one thinks something is true, if it is not in fact true and it is actually a false statement, then one commits slander, i.e., the mistake of truth is not a defense. You can think something is true when you say it, but if it actually turns out to be false and you've written it down, that's libel. And if you stated it orally to another person, that's slander. And you can't say to the court, well, I shouldn't be liable for slander. I shouldn't be liable for libel because what I said, I honestly and reasonably believed was true. It's not a defense. Privileges are also a defense to defamation. There's a huge amount of litigation as to what privileges are out there to make defamatory statements and what those privileges cover. First is absolute privilege. This is a right or immunity for defamatory statements, meaning that a person cannot be liable for defamation for any false statement made, regardless of intent or knowledge of the statement's falsity. It's like a get out of jail free card. You can make false statements and there's no liability. That's absolute privilege. It's a very narrow privilege, as you can imagine. The speech and debate clause of the Constitution protects those speaking on the House or Senate floors during debate. It also protects people debating and testifying before Congress. So that's a very narrow absolute privilege, is the speech and debate clause. Senators cannot be prosecuted for slander for what they say on the floor of the Senate or the House. There's another absolute privilege called judicial privilege. It protects those testifying in court or other judicial proceeding. That's also a very narrow absolute privilege. More common are conditional privileges. Conditional privileges are a right or immunity for defamatory statements made without actual malice. Actual malice is what they call a term of art in the law. A false statement is made with actual malice if the speaker knows the statement is false or exhibits reckless disregard for the truth. Basically, well, I'm pretty sure it's not true, but I'm not going to investigate it. Turning your head to the falsity of the statement and just blithely blurting it out. What you will often see in terms of conditional privileges is job recommendations. People often ask for a job recommendation from their previous employer when they're seeking a new job. There is some conditional privilege for job recommendations of the first employer, as long as they say something without malice. Most people tend to say nice things because they're afraid of slander or libel if they're asked to put it in a letter. But you will see some conditional privilege cases concerning job recommendations. Then there is the public figure privilege. It's a right or immunity for defamatory statements made about public figures, politicians, entertainers, sports stars. They have to be made without malice. But again, there's the public figure privilege that allows discourse about these people in the newspaper, on the internet. As long as a false statement you make about them is made without malice, that you don't intend to hurt them with it, then you have a privilege or immunity from prosecution for the intentional torts of either slander or libel. This was created or recognized in a landmark case called Sullivan versus the New York Times. It's a Supreme Court case from 1964. In Sullivan, the Supreme Court held that if a plaintiff in a defamation lawsuit is a public official or person running for public office, not only must he or she prove the normal elements of defamation, he or she must also prove that the statement was made with actual malice, meaning that the defendant either knew the statement was false or recklessly disregarded whether or not it was true. That's an important addition for public figures, and it gets very difficult to prove as a public figure. They say there's a price for fame, and this is one of them. The next intentional torts against persons that we're going to review are privacy torts. Privacy torts are normally known as the invasion of privacy torts. They're a group of torts that protect a person's right to keep certain facts out of the public arena, even if they're true. Now, these privacy torts are nicely described in your textbook, so I'm going to go over them relatively quickly. The first is false light. It occurs when publicity about a person creates an impression of that person that is simply not valid. Public disclosure of private facts. This occurs when someone publicizes a private fact about another that a reasonable person would find as highly offensive, such as a person's sex life or failure to pay debts. Then there's appropriation for commercial gain. This occurs when a person uses another person's name, likeness, voice, or other identifying characteristics for personal gain without that person's permission. This can happen even if they're dead. You can't just publish Elvis's face on your advertisement without paying his estate for the use of his likeness. The last is called intrusion upon seclusion. This occurs when someone invades a person's solitude, their seclusion, or personal affairs when the person has a right to expect privacy. A good example of this is two-way mirrors. Now, sometimes two-way mirrors can be used to deter shoplifting, but sometimes two-way mirrors can also be used to invade privacy, to watch women undress. The last intentional tort against persons that we're going to discuss is intentional infliction of emotional distress, generally abbreviated as IIED. Intentional infliction of emotional distress is also known as the tort of outrage in some states. In fact, in Kansas, in some of the older cases, you will see this tort referred to as outrage. Intentional infliction of emotional distress requires for the defendant to act intentionally or recklessly, and the defendant's conduct has to be extreme and outrageous, and the conduct must be the cause of severe emotional distress to the plaintiff. In some states like Kansas, to recover for intentional infliction, a plaintiff must show some physical symptoms or injury related to the extreme emotional distress suffered. Now, the bar for intentional infliction is high for both what is considered outrageous conduct and what constitutes emotional distress. Bad manners are not enough. Even racial slurs are not enough. The case law is ripe with all kinds of nasty, hurtful comments to people that don't rise to the level of intentional infliction of emotional distress. It's a very high bar. In addition, what constitutes emotional distress and the link between emotional distress and the physical injury has to be pretty immediate and pretty severe. For example, you have to suddenly start getting migraines, having physical symptoms. You have to be sick, you have to throw up. There's all kinds of different things. You have to basically be so upset you can't get out of bed. There's a lot of requirements, and even sometimes those things are not enough depending on the circumstances. What they say about intentional infliction in the cases is that the plaintiff's conduct must be so atrocious, so outside the boundaries of decency and civilized society, that any reasonable person would immediately and spontaneously declare the conduct outrageous, would say, "That's outrageous." It's kind of like knowing what obscenity is. I'll know it when I see it. The emotional distress has to be so severe that no reasonable person could be expected to endure it. And then there's what about public figures and emotional distress? Well, there's a very famous case called Hustler Magazine versus Falwell that was decided in 1998 by the Supreme Court that talks about public figures and intentional infliction of emotional distress. This case is not in your book, but I think it's an important one, so we're going to go over it a little bit. Hustler Magazine versus Falwell is an important case for our class because there are actually three different torts, intentional torts, that are at issue in Falwell. Intentional infliction of emotional distress, invasion of privacy, and libel. In Hustler Magazine versus Falwell, the Supreme Court, in a unanimous decision, held that the First and 14th Amendments prohibited public figures like Jerry Falwell from suing for damages from intentional infliction of emotional distress that results from caricature, parody, or satire of the public figure that a reasonable person would have not interpreted as factual. Hustler published a satiric ad concerning Jerry Falwell that portrayed him very negatively as an incestuous drunk in a spoof of a popular liquor ad running at the time. It was labeled satire in small print on the ad. Now, Jerry Falwell was very upset by the ad, and he sued Hustler Magazine. Falwell sued for libel, invasion of privacy, and intentional infliction of emotional distress. The judge, on summary judgment, as a matter of law, struck the invasion of privacy claim. And this is because the facts in the ad were considered false, and everyone knew they were false. For an invasion of privacy claim to survive, Falwell would have had to have admitted that the ad was true and that he was trying to keep the facts hidden. In other words, for invasion of privacy, you have to have a true fact that you are trying to hide, not a false fact. So after summary judgment, the case went to trial on libel and intentional infliction of emotional distress. Now, the jury found in Hustler Magazine's favor on the libel claim, since no reasonable person could have found that the facts in the ad about Falwell were true. However, they found for Jerry Falwell on the intentional infliction of emotional distress claim and awarded him $150,000. Hustler ultimately sought and was granted certiorari at the Supreme Court after losing their appeal in the Fourth Circuit. The Supreme Court reversed the Fourth Circuit and held that the emotional distress inflicted on Falwell by the ad was not a sufficient reason to deny the First Amendment protection to speech that is critical of public officials or public figures, even if the speech is unpopular, so long as it is not an obscene speech. We've finished discussing intentional torts against persons and are now going to discuss torts against property. The most common torts against property are trespass to realty, trespass to real estate, nuisance, trespass to personalty, also known as trespass to chattels, and conversion. Let's talk about trespass to real estate or trespass to realty first. This occurs when a person intentionally enters the land of another without permission, or intentionally causes an object to be placed on the land of another without permission, or intentionally stays on the land when the owner tells him to leave, or intentionally refuses to remove something he placed on the land when the owner tells him to remove it. It's not a defense to trespass that the defendant thought they had the right to be on the property or that they thought the land belonged to someone else. You cannot defend a trespass action by saying, well, I put this fence on the property because I thought it was my dad's property. That doesn't work as a defense. The intent in this intentional tort refers to the intent to be on the property itself. An example would be if you're a guest on someone's property and you get a little rowdy and they ask you to leave and you refuse, that at that point you become a trespasser on their property because you no longer have permission to be on the property. Another example would be to build a barn or a shed on someone's property. You may think it's your property, but it's actually not. And if the owner asks you to remove that shed and you refuse, that's trespass. Another intentional tort against property is private nuisance. Private nuisance occurs when someone uses their property in an unreasonable manner that harms a neighbor's use and enjoyment of his property. For example, suppose you want to landscape your yard, but you landscape the drainage in such a way that all the water from rains runs off of your property onto your neighbor's lots and pools there, making kind of a swampy area. That would be a private nuisance that your neighbor could sue you for. Trespass to personality, which is called trespass to personal property or trespass to chattel in some of the old tort books. This occurs when a person temporarily interferes with another's use or enjoyment of his personal property. The key for trespass to personally is that the interference is temporary. For example, suppose I take some tools from a neighbor's garage without permission and use them for a week. If some of the tools are damaged, I would owe damages for the broken tools because that's their direct damages. But if the tools were necessary for the neighbor's profession, suppose he was, say, a professional woodworker, I would owe damages from his inability to work as well because that would be a reasonable consequences of my taking his tools. It's reasonably foreseeable that if I took a woodworker's tools, that he might lose work because he doesn't have his tools to do the job. The last intentional tort is conversion. Conversion differs from trespass to personally because the conversion is permanent. Conversion occurs when a person permanently takes personal property from the owner's possession or control, and the owner can't regain the property. The tortfeasor would owe the damages for the full value of the items taken as well as any damages that flow from the loss. This would be if I took the tools and kept them, I would actually probably owe much greater damages because I would have to pay my neighbor back for not just the loss of the temporary use of the tools, but the permanent loss of those tools. So I would have to owe him for all of his lost wages, all of his lost work, plus the full market value of the tools that I took. The last category of intentional torts that we're going to discuss are intentional torts against economic interests. These are often referred to as the business torts as a group, and they include disparagement, intentional interference with contract, unfair competition, misappropriation, and fraudulent misrepresentation. These are torts that as a business person you may actually encounter in your business life. We're going to start with disparagement. Disparagement occurs when a statement is intentionally used to defame a business, product, or service. You may look at that sentence and see defame. Well, it's similar to defamation. Disparagement is similar to defamation, but instead of a person's reputation being defamed, it is the reputation of a business or its products or services which is tarnished by the false statement. The elements of disparagement are an intentional publication of a false statement of material fact that concerns a business, its products, or services, and that results in harm or loss. Usually this is calculated in terms of lost sales. A good example is falsely blaming a restaurant for an outbreak of E. coli, causing people to avoid eating at the restaurant and resulting in a loss of revenue. If someone makes a false statement that a restaurant is the source of an E. coli outbreak and they publish that either on the internet or they tell other people and that passes around and the restaurant loses customers and revenue, the person who made the false intentional statement about the E. coli outbreak is liable for the tort of disparagement. Another intentional tort against economic interest is intentional interference with contract. This occurs when there is a valid and enforceable contract between two parties. The defendant knows of the existence of the contract and its terms. However, the defendant intentionally takes steps to cause one of the parties to breach the contract, and the plaintiff is injured as a result of the breach that was induced. Basically, this prevents third parties from interfering in the contracts between two parties to their own benefit. An example of this would be luring away a key executive. Suppose there is a CEO of a corporation that has a 2-year written employment contract. Another rival firm wants to headhunt this CEO and lure him away. They know that he has a 2-year contract in writing with the first firm, but they succeed in getting him to break that contract and come over to their firm to work. That means that the first employer can sue the new employer for luring away that key executive if they suffer damages because the new firm intentionally interfered in the employment contract between the first firm and the executive, and the old firm suffered damages as a result of the loss of their CEO. However, that's interference with existing contracts. What if the contract doesn't yet exist? If the contract doesn't yet exist, just offering a better deal to compete for a contract or a potential contract is not a tort. That's competition. However, it is illegal and it is a tort to use illegal means to cause a party to enter into a contract, which is known as interference with contractual relations. That's a subset of intentional interference with contract. This occurs when you make an intentionally false statement about a business rival's products in order to steal a lucrative contract. You can't lie and cheat to get a contract. You can compete and offer competitive terms, but you can't cross the line and make false statements about your rival. Damages for intentional interference with contract can include losses due to the actual breach, as well as emotional distress and harm to reputation. Another intentional tort against economic interest is unfair competition. The term unfair competition occurs in a variety of legal settings. For example, it's often an issue in consumer protection cases. But in the business setting, it is when a party competes with another business, not to make a profit, but for the sole purpose of driving the other company out of business. There's a very good example of this in your book about the jewelry store. Suppose that there is a single jewelry store in a small town. Another person comes in and opens a jewelry store to compete with that jewelry store, but doesn't actually do it to make a profit because they offer huge markdowns. But the intent is to drive the first jewelry store out of business. Once they do that and they've eliminated the competition, then they open a legitimate jewelry store in the small town and they become the only jewelry store in town. That is an example of an intentional tort of unfair competition. The last intentional tort we're going to talk about is fraudulent misrepresentation. This occurs when a misrepresentation is made with the intent to facilitate personal gain and with the knowledge that it's false. It's much like criminal fraud. It's basically a lie to trick someone into a contract or to trick someone into a specific business action. The elements are that a party knowingly or with reckless disregard for the truth misrepresents material facts. The tortfeasor intended others to rely on the misrepresentation. The injured party reasonably relied on the misrepresentation. The injured party suffered damages due to the reasonable reliance, and a direct link, which is called causation, exists between the injuries and the reliance on the misrepresentation. For example, suppose someone is a diamond importer and they want to find another source of diamonds. They find a diamond broker who will sell them diamonds, and they go and examine the merchandise. And there are lovely diamonds of high quality that they're shown. But the actual diamonds are a plant or a feed, and the rest are actually cubic zirconia. These people are committing the fraudulent misrepresentational intentional tort because they're trying to trick the new buyer into believing that the entire load of diamonds that they're buying are high quality diamonds when only a few are and the rest are really cubic zirconia. That's an intentional fraud. Now, this is the end of intentional torts and the end of part one. Take a break and then listen to part two.